Well, good afternoon and welcome to another talk by the Two Temple Gardens Common Law team. We are returning to the extremely well-trodden path of vicarious liability, the latest instalment of which was the decision a few weeks ago of the Supreme Court in BXB. Now, why their lordships are so fascinated by vicarious liability is hard to say. But if anyone knows the answer to that question, it's going to be Tom Fairclough, who is one of Chamber's brightest young stars. He spent a year working as a judicial assistant in the Supreme Court, and perhaps in many ways already has something of the air of a Supreme Court justice about him. Tom's going to deal with stage one of the vicarious liability test. That's the nature of the relationship between the tortfeasor and the defendant. And then we're going to return to me, and I'm going to deal with stage two of the test, that is the connection between that relationship and the tortfeasor's wrongdoing. Over the years, I've done a very large number of vicarious liability cases. I was counsel in Mattis and Pollock, which was one of the first Court of Appeal cases after Lister. I was rather more recently instructed on behalf of the defendant in Mohammed, which was, of course, another case decided by the Supreme Court eventually. Right, that's enough of me. And I'll pass over to Tom to deal with stage one.
Thank you, Roger. Thank you, everybody, for attending. As we said in the invitation to the talk, the Supreme Court's most recent judgment is the very latest in a very long line of apex court decisions on vicarious liability. And as Roger mentioned, he's been involved with one of them. While some areas of law have their leading cases in great 19th century jurisprudence and oratory, vicarious liability is an area of law that is being examined by the Supreme Court on a near yearly basis. And the reason for this is probably apparent from what is said in paragraphs 1 and 2 of the BXB judgment, where Lord Burrows says this: vicarious liability in tort is an unusual form of liability. This is because the vicariously liable defendant is held liable and treated as a joint tortfeasor, not because it has itself committed a tort against the claimant, but because a third party has committed a tort against the claimant. Vicarious liability, therefore, does not rest on the defendants having owed any duty, whether strict or of reasonable care, to the claimant. It was the third party, the tortfeasor, who owed that duty to the claimant. Given the unusual nature of vicarious liability, it is perhaps not surprising that its precise rationale has proved contentious. And without wanting to do a spoiler alert, I think the precise rationale for vicarious liability is still contentious after the fourth or fifth recent Supreme Court judgments on the issue. With that in mind, Roger and I want to look at the latest missive from the Supreme Court, the BXB case, the facts of the case, what was decided and where next. I'm going to talk about the facts of the case and what the Supreme Court calls stage one, the question of what relationship is needed between the tortfeasor and defendant to impose vicarious liability. And Roger is going to talk about what the Supreme Court calls stage two, i.e. the connection between that relationship and the tortious conduct in question. Although quite a lot of the excitement and focus is often on stage two debates, not least because that's usually questions about what the wrongdoer has actually done, and quite often some interesting conduct to make it worth taking to court. The law on stage one has moved on too. Certainly when I was taught vicarious liability, which wasn't that long ago, we were essentially taught that vicarious liability is just about employer and employee relationships and not about independent contractors. And what you had to do was look to see if the relationship could be fit into the employer-employee box. And that probably still is the starting point. But the shift in emphasis in recent years has been from strict categorization of relationship between tortfeasor and defendant to instead looking at the substance of that relationship. That is the relationship akin to employment sufficient to justify the imposition of vicarious liability, even if in fact the tortfeasor is not an employee of the defendants. This akin to employment test was first employed in the way we know it in, as far as I can find, a 2004 Supreme Court decision in Canada called Doe and Bennett, which was itself imported into English law in the first instance decision of JGE and the English provenance of Our Lady of Charity, a 2011 judgment by Mr. Justice Macduff that Lord Phillips described as lucid and bold in the Catholic Child Welfare Society Supreme Court case from the early 2010s, which, as many of you will know, is often the starting point when considering whether a relationship is one to which vicarious liability can attach. This obviously brings its own problems. As ever, when you stop looking at formal, rigid distinctions and instead focus on substance and questions of fact and degree, you open the door to new arguments and new types of relationship to which vicarious liability might attach. And what that does is inevitably generate uncertainty, and with uncertainty, litigation. And that might be good for the lawyers, but not necessarily for advising clients as to the outcome. That has certainly been the case in recent years, and BXB is just the latest, but undoubtedly not the last, example of this. So on to BXB itself. The facts of BXB are unfortunately, but probably predictably, sad. But given the fact-sensitive nature of vicarious liability, I will go through them briefly. The appellants were the trustees of a congregation of Jehovah's Witnesses, the Barry congregation, that held services thrice weekly. Two of these were in the Kingdom Hall, the Jehovah's Witness place of worship, and one service each week was in the family home and small family worship settings. The claimant and her husband attended the Barry congregation from 1984. They were friends with a Mr. and Mrs. Sewell, originally through work of Mr. Sewell and the claimant's husband, but also through the Barry congregation. And within the congregation, Mr. Sewell was an elder, which is a senior position in the Jehovah's Witness hierarchy. The claimant wasn't an elder, she was below him in the hierarchy, not least because she was a woman and women can't be elders in the Jehovah's Witness faith. But Mr. Sewell, as time went on, Mr. Sewell became a heavy drinker from the late 1980s, and this resulted in an unfortunate incident between the claimant and Mr. Sewell. The claimant and her husband had been out knocking on doors, evangelizing with Mr. Sewell and his wife. They then went to a pub lunch before returning to the Sewell's home, and whilst in the family home, Mr. Sewell raped the claimant. Several years later, in 1993, the claimant reported the rape to the Barry congregation. Mr. Sewell was removed as an elder, and he was convicted at a trial in 2014 of the rape of the claimant and abuse of others. The claimant subsequently developed psychiatric injury and brought a claim against the Barry congregation in 2017. At trial, the Barry congregation said they were not vicariously liable for Mr. Sewell's actions, both because the relationship wasn't akin to employment and because the rape was not in the course of the relationship, the latter of which Bodger will address in his talk. Mr. Justice Chamberlain found for the claimant. Roger will talk about the second stage, but on the first stage, Mr. Justice Chamberlain found that Mr. Sewell's relationship with the Barry congregation was akin to employment. The Barry congregation appealed to the Court of Appeal and lost again. And so we went to the Supreme Court, where the Barry congregation had a third attempt at success on stage one. Lord Burrows, who gave the only judgment for the court, focused his review on the law, and particularly for stage one, from Lord Phillips' judgment in the Christian Brothers case, where the stage one test was met for vicarious liability because a Christian brother, whilst not an employee, was in a relationship akin to employment with the Christian Brothers Institute, given, and I quote, "There was a hierarchical structure and the brothers were directed to undertake the teaching activity. They were doing so in furtherance of the objectives of the Institute, and they were required to conduct themselves as teachers within the rules of the Institute. It did not matter that the brothers were not paid as such. and they were bound, or that they were bound to the institute by vows rather than by contract. Lord Burrows continued to review, as it were, the Supreme Court highlights of the last decade. He moved to the case of Cox and the MOJ, a 2016 Supreme Court case about the prison service and whether a prisoner working for a ward but not an employee could be in a relationship sufficient to ground vicarious liability with the Ministry of Justice. And in Cox and MOJ, the answer was yes. Lord Reed holding in that case that when prisoners work in the prison kitchens or in other workplaces such as the gardens or the laundry, they are integrated into the operation of the prison, with their services being given for the direct and immediate benefit of the prison service. Penultimately, Lord Burrows reviewed Arms and Nottinghamshire County Council, a 2017 Supreme Court case, where it was said that a local authority is vicariously liable for foster parents who adopt children or foster children within the local authority's remit. And finally, on the stage one question, the question about relationship, Lord Burrows reviewed Barclays Bank, a 2020 Supreme Court judgment where it was said that a bank was not vicariously liable for a doctor to whom the bank sent its employees to undergo medical examinations. And that was because the doctor was acting for his own business. It could not be said that his relationship was akin to that of employment with the bank. Having done his whistle-stop tour of the Supreme Court's greatest hits, Lord Burrows turned to what he said the current law was and summarised the current law. And for stage one, he said that the test is whether the relationship between the defendant and the tortfeasor was one of employment or akin to employment. And when looking at akin to employment, a court needs to look carefully at the features of the relationship to see what is similar to or different from a contract of employment, albeit at this stage, I note that what constitutes the characteristics of a contract of employment wasn't itself defined in the judgment. Lord Burrows makes clear that this exercise is ultimately fact dependent, but Lord Burrows says that akin to employment may include, but note it doesn't have to include, so it's not a prescriptive test, 6 factors. And those factors are these. First, whether the work was being done for payments of money or payment in kind. So for the religious cases, quite often accommodation and food, but not payment. 2, how integral to the organisation the work being carried out by the tortfeasor is. 3, the extent of the defendant's control over the tortfeasor. 4, whether the work is being carried out for the defendant's benefit. 5, what the situation is with regard to appointment and termination. And 6, whether there is a hierarchy of seniority into which the relevant role fits. Applying those factors, Lord Burrows, in just over a page of judgment, Lord Burrows found the relationship between Mr. Sewell and the Barry congregation was akin to a relationship of employment. Whilst unpaid for his role, Mr. Sewell was an elder in the Jehovah's Witness organisation. He was carrying out work on behalf of and assigned to him by the organisation. Such work was integral to the furtherance of the aims and objectives of the organisation. And as an elder, he held an official position in a hierarchical community into which an elder fit fairly near the top, but not quite at the top of the Barry congregation. In short, Mr. Sewell's duties were to serve that organisation. He was not acting, as it were, in pursuit of his own business, as the doctor in Barclays Bank was. With stage 1 passed, stage 2 became the battleground, on which I'll hand over to Roger in a moment. But as a final thought on stage 1, I'll say this. It's all well and good saying to look at the relationship and see if there is a relationship akin to employment, albeit I'll note again, employment relationships are so varied nowadays that I'm not convinced it's entirely clear what that means. But that aside, this test might work well for prisoners or the monastery cases, not least because where there is a prisoner or a monk living in a community, they are completely under the control of the counterparty to that relationship, being directed by that counterparty. They receive benefits in kind and so on. But they are different to this case. Mr. Saul was an elder, but he didn't work for the congregation full time. He had a full-time job elsewhere. He wasn't remunerated in cash or kind. He was essentially a volunteer within his community. And one can think about more casual relationships, and can they lead to the imposition of vicarious liability? So what about an occasional charity volunteer, or an occasional cricket player for a small local team who crashes his car on the way to a match whilst he's carrying all of the equipment, or the treasurer of a small unincorporated bowling club who assaults someone after a match? One can see how such examples feel different, yet on Lord Burrows' analysis and on this fact-sensitive, let's see how like employment it is or isn't, those examples may well pass the stage 1 test. As said, this isn't straightforward, but the latest missive from the Supreme Court, although important, probably doesn't help resolve this contentious area, and is instead just another step on the road trying to find some coherence and finality on this important area of law. And with that note, I'll hand over to Roger.
Right, well, thank you, Tom. We'll turn now to stage 2, and I think it's possible to divide the last 20 years of case law into 3 distinct periods. The first was the period following the decisions in Lister and Dubai, where the courts tried to apply the newly defined close connection test. The second period was ushered in by the Supreme Court following the case of Mohammed, where rather different language was deployed, and there was certainly a perception that the boundaries of stage 2 had changed significantly, and that we were in a more claimant-friendly era. And the third stage, the third period, which is very much the retreat from the decision in Mohammed, following the decision in Morris and others, in which there is a return towards the language of Lister and Dubai and an altogether more restrictive approach. And as we'll see, BXB is very much part of period 3. It's very much part of the retreat from the decision in Mohammed. I'm not going to go through the details of 20 years of case law in minute detail, you'll be pleased to hear. In summary, the first stage, the Lister and Dubai stage, set out a deceptively simple test. The test, as set out by Lord Nichols in Dubai, was whether the wrongful conduct was so closely connected with acts the employee was authorised to do that it was fairly and properly regarded as done by the employee while acting in the ordinary course of the employee's employment. So you'll see there are 2 concepts that lie at the heart of that test. The first was the consideration of the relationship between the tort and the phrase acts the employee was authorised to do. And secondly is this determination of whether it's fair and proper to regard the tort as done during the course of employment, which according to Lord Nichols involved principally a consideration of past case law. Now, the difficulty with the test, as was pointed out by Lord Nichols himself, is that whilst the close connection test focuses attention in the right direction, it affords no guidance on the type or degree of connection which would normally be regarded as sufficiently close to give rise to vicarious liability. So the courts grappled with where the boundaries should be drawn, and a very large number of cases followed. They involved trigger-happy policemen in the Caribbean, violent bouncers in seedy Woolwich nightclubs, racist murderers in Scottish supermarkets, and dim-witted practical jokers in Cambridge. That period came to an end with the restatement of the law in Mohammed, which Zaid appeared in throughout on behalf of the defendant. It involved a Somalian who'd been beaten up by a racist petrol forecourt attendant. And at first instance, and the Court of Appeal, the courts had frankly little difficulty applying Dubai and Lister, and the claims failed. But when it got into the Supreme Court, we heard for the first time rather different language being deployed. So whereas in Dubai, the starting point had been acts the employee was authorised to do, in Mohammed, Lord Toulson preferred to refer to fields of activities which have been entrusted by the employer to the employee. Now, unsurprisingly, lawyers and judges took the view that if your starting point is something as vague as a field of activity, rather than more tightly defined acts the tortfeasor was authorised to do, it is not surprising if your finishing point encompasses a great many more cases. Secondly, whilst the House of Lords in Dubai had stressed that you should determine the idea of whether it's fair and proper principally by looking at previous case law, in Mohammed, Lord Toulson instead suggested that one should look at the principles of social justice, which he went on at some length to explain went back to the decisions of Chief Justice Holt in the 17th century, a judge who hitherto had been principally famous for dealing with witchcraft cases. Again, it's not difficult to see why this rather more nebulous concept of social justice was thought by many to have expanded the boundaries of vicarious liability. So there followed a period of a few years where we had decisions such as that in Bellman, where a managing director of a small company was liable for an assault committed after a Christmas party. This period came to an end when the Supreme Court realised what they had done, and in the case of Morrison, which was not a personal injury case, it involved data being leaked by an employee. And whilst the Supreme Court didn't say they'd got it wrong, they did say it was necessary to address the misunderstandings which had arisen following Mohammed, the fault obviously being that of the judges and lawyers who were trying to interpret Mohammed rather than the decision in the first place. And Lord Reid made a number of key points in Morrison. First, he said that Mohammed did not represent a change in the law. I mean, in some ways, this shouldn't have been surprising, as Lord Dyson, who gave the only other judgment in Mohammed, said precisely that. But he went on to say that this idea of fields of activities should be treated as referring to no more and no less than the phrase used by Lord Nichols in Dubai, acts the employee was authorised to do. And the third really key point in Morrison was that this requirement that it should be fair and proper for an employee to be vicariously liable for an employee's torts did not and was not an invitation for the court to apply abstract 17th century principles of social justice, or perhaps even worse, for judges to apply their own concepts of fairness, but to return to the Lister approach of applying previous case law. So that brings us then to BXB. It's important to bear in mind that the first instance decision in BXB was in what I've been calling period 2. It was after Mohammed, but before Morrison. And Mr. Justice Chamberlain found that the relationship that was sufficiently closely connected to the torts that it would be proper to find the defendant vicariously liable. He pointed to a number of factors. He said that Mr. Saul's position as a ministerial servant was an important part of the reason why the claimant had started to associate with him. He went on to say that but for Mr. Swales' position as an elder, the claimant would probably not have remained friends with him by the time of the rape. He said that the defendant significantly increased the risk that Mr. Swales would sexually abuse the claimant by creating the conditions in which the two might be alone together. And they said that one of the reasons that the rape was carried out was Mr. Saul's belief that an act of adultery was necessary to provide scriptural grounds for him to divorce his wife. So those reasons, according to Mr. Justice Chamberlain in the first instance, were sufficient to give rise to stage 2 of the vicarious liability test. And the Court of Appeal, although they put the reasoning in slightly different terms, agreed. Lady Justice Nicola Davis thought that on the facts, what's relevant was the conferral of authority by the Jehovah's Witnesses upon its elders, coupled with the opportunity for physical proximity. But when the matter came before the Supreme Court, they allowed the appeal. Now, the first thing to emphasize is that they were very clear that the law remained as stated in Dubai and Lister. They've slightly tweaked the wording of the test, but not, I think, in a way that affects how it's implemented. So they've removed the word while acting in the ordinary course of the tortfeasor's employment to simply acting in the course of the tortfeasor's employment, and they've added after employment or quasi-employment. But both those changes are doing no more than reflecting what the law is and do not, in my view, represent any change. The only other change, and time will tell how significant this is that they went on to state that it could be a useful final check on the justice of the outcome to stand back and consider whether the outcome is consistent with the underlying policy of vicarious liability. Now, the underlying policy that they identified was what they call the enterprise risk policy, i.e. that it's just that an enterprise which takes the benefit of activities carried on by a person integrated into its organization should also bear the cost of harm wrongfully caused by that person in the course of those activities. But this mixing of policy behind the law and the legal criteria which need to be satisfied, even if it means simply a final check, in my view, just simply muddies the waters and invites further litigation and is not really necessary. What is one supposed to do, for example, when the legal test suggests one answer and the enterprise risk policy suggests another? For example, one might well see that if one's simply looking at a matter of policy, something like horseplay is very much part of the enterprise risk, but it isn't something that normally gives rise to vicarious liability when applying the correct legal criteria. Now, my suspicion is that this, in practice, problems like this won't particularly arise because I think courts will stay pretty closely to the Dubai and Lister test. And I say that particularly because the pretty coruscating demolition that the Supreme Court gave to the reasoning applied in the first instance in the Court of Appeal in BXB. So they were quite frank that a number of errors had been made by Mr. Justice Chamberlain, some of which they said were repeated by the Court of Appeal. In summary, they said that neither in the first instance or in the Court of Appeal had set out the correct close connection test as laid down in Dubai and Lister. Secondly, they pointed out that the factors that had been relied on in the first instance in the Court of Appeal were really no more than background. So the early flowering of the friendship shouldn't have been any relevance to whether the second stage was satisfied. The fact that before lunch on the day of the rape, the claimant, Mr. Saul, had been carrying out Jehovah's Witness activity was again essentially irrelevant, except as background. And thirdly, they made very clear the fact that but-for causation is insufficient to satisfy the close connection test. And they held that on proper analysis, there should have been no finding of vicarious liability, that the rape was not committed whilst Mr. Saul was carrying out any activities as an elder on behalf of the witnesses. In contrast to the sexual abuse cases, at the time of the rape, he wasn't exercising control over the claimant because of his position as an elder, and he wasn't wearing what they called the metaphorical uniform of an elder at the time the tort was committed. So they concluded that the second stage was not satisfied and the claim should fail. So where does that leave the law now? Well, in my view, the following principles can be derived from the various authorities. The first key point is that mere opportunity is not enough. So the opportunity that an enterprise affords an employee to commit a tort is relevant, but it is not a determinative factor. So the mere fact that the tort occurred whilst the tortfeasor was working during working hours or on the employer's premises is not sufficient by itself to give rise to vicarious liability. Secondly, the mere fact that the employee was expected to come into contact with the victim isn't sufficient to give rise to vicarious liability. That's the principle behind many of the horseplay cases. The mere fact that those people are expected to come into contact isn't sufficient by itself to give rise to vicarious liability. Thirdly, some additional factor beyond mere opportunity is crucial. And case law gives some good indicators as to what those sort of things might be. Firstly, if the assailant is seeking to further the interests of the employer. So in many of the bouncer cases, you get people beating up guests because of their role as a bouncer. That's very likely to give rise to vicarious liability. Or if there's an expectation that the tortfeasor will use violence. So there was vicarious liability in Gravel, which was a fight in a rugby match. Matters of Pollock, another bouncer case. Those cases give rise to vicarious liability. Equally, if there's an expectation that the tortfeasor will restrain members of the public, so Fennelly, which was a ticket inspector case, or Brown, which was a security guard supervising entry to a football match, those all gave rise to vicarious liability. Perhaps the high water mark for these sorts of cases is Wallbank, in which it was held that the mere fact that there was a possibility of friction inherent in the workplace was sufficient to give rise to a vicarious liability. I think if you're acting for a claimant, Wallbank is a case that often requires study. Or finally, in this regard, the fact that power has been confirmed on the employee in relation to the victim. But as BXB makes clear, that by itself probably isn't enough. What they need to be doing is wearing the metaphorical robes of office at the time the tort is committed. These cases where there has been a finding of vicarious liability need to be contrasted with those where, to use the phrase that is so beloved of the judiciary in these cases, the tortfeasor's on a frolic of his own, or where the assault is properly classified as a random incident. So the murder of a colleague by a racist shelf-stacker, it's difficult to say, in Vakeveen was not such as to give rise to vicarious liability. The horseplay cases, Wilson involving a supervisor pulling a junior employee's hair, or Graham, which involved a worker in a garage spraying somebody with highly flammable substance and then setting it alight with a cigarette lighter. Those cases very often, they won't always, but very often have been found not to give rise to vicarious liability. Nor have cases involving personal vendettas, acts of purely personal vengeance often fall outside the ambit of vicarious liability. However, before defence get too carried away, it is important to remember the fact that the tort is intentional or criminal or carried out exclusively for the benefit of the tortfeasor, or even if it's contrary to direct instructions or the very negation of employee's duty, will not by itself mean no vicarious liability. So where have we ended up? It seems to me that the test as set out in Lister and particularly by Lord Nichols in Dubai is very much back at the heart of the stage 2 tests. And I think the court will take some persuading to go beyond the current boundaries. If you are looking for analysis, I think the best case in terms of analysis of the individual factors that one takes into account in these intentional tort cases is amazingly not an English court, despite the proliferation of decisions in England over the last 20 years, but the Canadian decision of Basley, which absolutely grapples with these issues. It's been praised in a number of cases. And if you are looking for a way into these cases, I think Basley, which is a 1999 Canadian decision, is the best case to look at. And thirdly, I do think that policy arguments alone are unlikely to persuade a court, albeit that door has not been entirely shut. I think it is likely that the law may now be entering a more settled stage. But I say that as someone who currently has a case where a claimant is claiming that a boarding school should be vicariously liable for the sexual abuse carried out by a prefect. So it may well be that in a couple of years' time, we are back to discuss the Supreme Court's decision in relation to that. Well, that brings us to an end. Thank you very much for your time. If you do want to watch this all over again, well done. We have a YouTube channel where you can do so. We look forward to seeing you again soon. Thank you very much and good evening.